Please, Lord. Lord, I beg to mention for listing of a matter. In a prayer.
Not for today.
I beg to mention.
Please, Your Lordship. I beg to mention an IF donation of legal.
Regarding that hearing Parthan matter, my lord, both parties are ready. But Your Lordship on the last day said that some accommodation Your Lordship will do it. So can we take a time or
Yeah, we can do it today. No problem.
at what time? Just then.
Today itself. We can.
Because Your Lordship
I have 4-5 matters.
Yeah.
Then we can give you an item. Because 9 to 14 only. We'll finish that off and then get to you.
At what time? Approx. Sorry to say.
It won't take an hour, I suppose. Won't take an hour.
11:30 by 12 will be.
Not 12, 11:30.
Taken.
And the top of the list items I have given. Some we have made CAB, some we have deferred, and the others will get it listed next week. You need not wait for that. 9 of material. Heard Mr. P.K. Roy Chaudhary, Learned Counsel for the petition. I also heard Mr. M.P. Goswami, Learned Additional Public Prosecutor appearing for the state. Also, the present revision petition has been instituted. Yes. Huh? No, we are just passing the order only. We have heard them. The present petition is instituted. Assailing the order dated, judgment dated 10/7/2013, passed by the Learned Additional Session Judge bracketed FTC Borpeta in Criminal Appeal number 6/2012, dismissing the same and thereby affirming, thereby upholding the judgment dated 28/4/2012, passed by the Learned SDJM bracket M Bozali in GR case number 1781/2006, convicting and sentencing the petitioner herein under section 406 IPC. Relax, sit. Also, the prosecution case in brief is that on 10/12/2006, one Mir Abul Qasim, then Inspector of Schools Borpeta, had lodged an FIR with the record to do with the Borpeta officer in charge Borpeta Police Station, inter alia, stating therein that the head petitioner herein, who is the headmaster of Karaguri Watar Ansolik High School, yet Sailova, page 10 of the same, had collected question papers of class 10 board examination from the secretary of the district board by submitting a requisition. Also, it is alleged in the said FIR that on 9/12/2006 at around 2:30 p.m. when Nirendra Pujari, secretary of the district board, visited the school along with 3 other members of the board, they found that no examination was held. Also, it is further alleged that the question papers having remained with the accused, a notice was issued to the accused to return the question paper packets. However, the accused did not return the same. Also, apprehending that the accused may do something malefic with the question papers, thereby causing disturbance to the secrecy of the examination as a whole, the FIR came to be lodged. The police, on receipt of the said FIR, registered the same as Borpeta PS case number 877/06 under section 406 IPC. Also, on conclusion of the investigation, the police laid a charge sheet under section 406 IPC against the petitioner herein. a charge, full stop. The learned trial court on appreciating the material, appreciating the materials coming on record had framed a charge under section 406 IPC against the petitioner herein. The petitioner, full stop, the petitioner having pleaded not guilty and claimed to be tried, a trial ensued. Full stop. During the trial, the prosecution examined 15 witnesses, and thereafter the petitioner herein was examined under section 313 CRPC. Also, on conclusion of the trial, the learned trial court, by judgment dated 28/4/2012, proceeded upon the learned trial court, upon appreciating the evidences coming on record, proceeded to convict the petitioner herein under section 406 IPC and sentenced him to undergo rigorous imprisonment for 1 year. Subpara. The petitioner being aggrieved with the conviction, his conviction under section 406 by the learned trial court, by judgment dated 28/4/2012, assailed the same before the session judge Borpeta by way of filing an appeal, being criminal appeal number 6 of 2012. Full stop. The appellate, the appeal was considered by the additional session judge bracketed FTC Borpeta. The appellate court, upon appreciating the evidences coming on record, was pleased to dismiss the said appeal. Judgment dated, dismiss the said appeal, thereby upholding the conviction of the petitioner under section 406 IPC by the learned trial court. Full stop. Being aggrieved, the petitioner has instituted the present proceedings. Full stop. I have heard the learned counsel, Mr. P.K. Roy Chaudhary, learned counsel for the petitioner, by taking this court through the evidences, to the deposition of the prosecution witnesses, as well as the examination, the statements made by the petitioner under section 313, during the trial, has submitted that at best what was established against the petitioner is that the question paper were entrusted to him. He submits that the evidences coming on record had not established the fact that the petitioner herein had either misappropriated or converted it to his own use, or used it or disposed it in violation of any direction of law prescribing the mode in which such trust was to be discharged. So he submits that the question papers as entrusted to the petitioner were recovered by the police, and a perusal of the requisition slip submitted by the petitioner as well as the Caesar memo would go to reveal that the question papers as handed over to the petitioner were all recovered by the police. Mr. Chaudhary, learned counsel for the petitioner, has further submitted that the materials brought on record does not indicate that the petitioner in any manner had misused the question papers in use, question papers received by him from the authorities. He submits that although there is a although the PW10 during his deposition had deposed that the class 10 examination question paper got leaked near the accused, near the school of the petitioner, however, the said deposition was not a direct deposition, but was a reiteration of the was a statement with regard to the information received from the headmaster of another school. Mr. Chaudhary has submitted that the respondent authorities that the prosecution has not brought on record any material to establish that the question papers that the petitioner was involved in the leakage of the question papers before the examination was held. Also, Mr. Chaudhary, with regard to the deposition of PW10, that the one question paper in the subject of maths was received less by the was recovered less by the police from the petitioner herein submits that the requisition as made by the petitioner was for issuance to him of question papers for 15 students who were to appear from the school in question for the maths paper. First up, he submits that the Caesar memo would reveal that the police had recovered 16 question papers, right? 16 question papers from the petitioner. First up, the prosecution has not brought on record any explanation in this connection. Also, Mr. Chaudhary submits that the question papers as purportedly received by the petitioner having already been recovered by the police, there could have been no apprehension of the petitioner misusing the question papers handed over to him in any manner. Accordingly, he submits that accordingly, Mr. Chaudhary submits that the ingredients requisite for bringing home a charge under Section 406 have not been established by the prosecution against the petitioner in the present proceedings. He therefore praised that the conviction of the petitioner under Section 406 would mandate an interference from this court. Mr. M.P. Goswami, Learned Counsel for the Learned Additional Public Prosecutor, has submitted that the evidences coming on record, more particularly the evidence adduced by PW10, by PW4 and PW10, brings on record that although the petitioner had received the question papers for purportedly conducting the Class 9 examination in the school, however, admittedly, the said examination was not conducted. Also, he submits that the petitioner he further submits that the evidences coming on record had also brought evidences adduced by the prosecution witnesses had brought on record that there were no students in the school of the petitioner, which was a venture school, and accordingly, there was no necessity for the petitioner to receive the question papers in question papers from the authorities. He further submits that the evidences having revealed that no examination has been carried out, and there being an apprehension that and there also being material of the leakage of the paper, leakage of the question paper of Class 9 examination, the ingredients of Section 406 IPC stood established against the petitioner in the matter, and accordingly, the conviction of the petitioner under Section 406 IPC would not mandate any interference. I've heard the Learned Counsel for the parties and also perused the materials available on record. Also, the evidences adduced by the witnesses have brought on record the fact that the exams, Class 9 exams in the school, were either held or not held. Contradictory evidences are available on record in this connection. Also, PW4, who was the then Inspector of Schools, Borpeta, had deposed in the matter as Mir Abul Qasim, who was the then Inspector of Schools, Borpeta, had deposed during the trial as PW4, and he had deposed that Nipendra Pujari, who was the secretary of the district board, had gone to the school of the petitioner during the examination time for inspection and had found that the examination was not held. He further deposed that Nipendra Pujari had also not found the petitioner in the school at the relevant time at the time of the inspection. PW4 further deposed that the exam not being held, The question papers on being asked to be returned, comma, the petitioner had not returned the same. And accordingly, the FIR was lodged in the matter by Nipendra Pujari. During his cross, the PW4 had deposed that he had not received any complaint from any candidate of class 9 examination from the said school. Also, PW10 Nipendra Pujari, who was the secretary of the district class 9 board examination board of Barpeta district, deposed that in the year 2006, in the month of November 2006, on getting information that no examination was held at Karaguri Othar Anchalik High School, he along with his staff, had proceeded to the school for carrying out an inspection and on such inspection found that no examination was held in the school. The petitioner was also deposed to have been not found in the school at the time of the inspection. Also, on reporting the matter to the inspector and filing of the FIR, it was deposed that the police had seized the question paper from the accused, which was given to him from the center. Also, PW10 disclosed that there ought to have been 17 numbers of maths question paper, but it was found that during the season, one question paper was less. And that I have said it would have been 17 numbers of question, but one is less. That I have said. Also, PW10 further deposed that the school of the petitioner is a provincialized, is not a provincialized school, and further that the headmaster of Pachim Poka Azad Memorial School collects the question paper for the schools which falls under Pasim Poka Center, and the school of the petitioner falls under Pasim Poka Center. Also, PW11, who is also a member of the class 10 class 10 examination board Barpeta, during his deposed that he had got information that question papers of class 9 examination were leaked out near the school of the petitioner, and he had received this information from master of Pahumara High School. He further deposed as to the manner in which the matter after completion of the inspection was processed and leading to the filing of the FIR. PW12, Taibur Rahman deposed that he was the officer in charge of Pasim Paka Center, and as the petitioner had given a requisition for the question papers for the examination, the question papers came to be handed over to the petitioner. He also deposed that that during the inspection carried out, no examination was found to be held in the school of the petitioner, and the petitioner was also not found in the school at the relevant point of time. Also, PW 15, the investigating of SI Mahendra Soika, the investigating officer, during his deposition, deposed that he had he had visited the place of occurrence, recorded the statement of the witness, and the petitioner herein himself appeared along with the documents at the police station on 15/12/2016, and the documents were seized at the police station in presence of witnesses. He further deposed of having arrested and forwarded the petitioner herein to the court and of submission of the charge sheet on completion of investigation. The SI during his deposition also deposed that the petitioner herein had taken the question papers from PW. The investigating officer during his deposition had deposed that the PW12 Taibur Rahman during his deposition before him, during recording of his statement before him, had stated that the accused had taken question papers from him, bracketed PW12, but had not disclosed the number of question papers received by the accused. Also, basing on basing on an appreciation of the evidences coming on record, the learned trial court proceeded to draw the following conclusions. Page 16, A to A. So, basing on the said conclusion, the learned trial court proceeded to hold the guilty, proceeded to convict the appellant herein under section 406 IPC and sentenced him as noticed herein above. Also, the learned appellate court wide judgment dated 10/7/2013 on appreciating the evidences coming on record had proceeded to draw the full had wide judgment dated 10/7/2013 proceeded to draw the following conclusions. Page 28, B to B. Also, the petitioner herein having been convicted under section 406 IPC, the provisions of 406 being relevant, the same is extracted herein below. 406 to extract co-edible. A perusal of the provisions of section 406 IPC 100%. Would would reveal that the same mandates punishment for commission of an offence of criminal breach of trust. Full stop. Criminal breach of trust has been explained in the provisions of section 405, the provisions of section 405 being relevant, the same is extracted herein below. So a perusal of the provisions of section 405 would bring to the forefront that whoever being entrusted with property or with any dominion over property, dishonestly misappropriates or converts to his own use that property or dishonestly uses or disposes of that property in violation of any direction of law, prescribing the mode in which such trust is to be discharged, or of any legal contract express or implied, which is made touching the discharge of such trust, or willfully suffers any other person to do so, is said to have committed a breach of trust. Also, applying the provisions of section 405 to the evidences coming on record in the present against the petitioner in the trial, this court finds that the evidences have brought on record that the question papers were duly entrusted to the petitioner, and during the time the question papers remained in custody of the petitioner, he had dominion over these things. However, this court is of the view that mere entrustment of the properties would not bring home a charge, would not satisfy the requirements of the, it would not be enough to satisfy the ingredients of section 405 with regard to the commission of an offence of apostrophe without criminal breach of trust. Also, the evidences brought on record in the matter reveal that the examination this court, even if it holds that the examination in the school was not held by the petitioner and the question papers were not utilized, the same by itself would not constitute a misappropriation of the question papers and or dishonest use thereof, inasmuch as the evidences coming on record have revealed that reveal that the petitioner had produced the question papers before the police and the same were seized. So the question papers admittedly were given to the petitioner on a requisition made by him. Also, a perusal of the requisition, which was exhibited as exhibit number,
Material exhibit number
material exhibit number 1, would reveal that the petitioner had submitted a requisition for a particular number of question papers against each of the subjects involved. Also, the evidence coming on record being only with regard to the question paper pertaining to the subject of mathematics, it is seen that the petitioner in a said requisition had disclosed that there were how many? 15 students in the school who were to undertake the examination in the mathematics paper. The Caesar memo prepared by the police after the lodging of the FIR on the question papers being produced before it by the petitioner hearing, it is reflected that with regard to the maths paper, number of printed pages were brought on record. Also, accordingly, there being no evidence adduced by the prosecution with regard to the actual number of question papers received by the petitioner, in pursuance to the requisition made by him in the matter, comma, the requisition made by the petitioner having disclosed that the number of candidates undertaking the mathematics paper being only 15 and admittedly 16 question papers having been seized from the petitioner, comma, this court is not in a position to conclusively hold that the question papers as entrusted to the petitioner were not recovered from him by the police after the filing of the FIR in question. Full stop. In view of the above position, comma, this court is of the considered view that the evidences coming on record has not satisfied the commission of the offense of criminal breach of trust by the petitioner herein, inasmuch as the misappropriation of the question papers and dishonest use thereof in violation of the directions issued in this connection for its use have not been established against the petitioner herein. Also, the learned trial court as well as the appellate court had not appreciated the evidences coming on record with a view to ascertain as to whether the ingredients of Section 405 stood established against the petitioner herein. Also, this court having found that the ingredients of Section 405, that is with regard to the commission of offense of criminal breach of trust having not been established against the petitioner herein beyond a reasonable doubt, comma, the conviction of the petitioner under Section 406 has been rendered unsustainable, requiring its interference by this court. Full stop. In view of the above, the conviction, or in view of the above discussion, the conviction of the petitioner herein under Section 406 stands set aside. Consequently, the judgment dated 28/4/2012 passed by the learned SDJ M bracketed M Bozali in GR case number 1781/2006, as well as the judgment dated 10/7/2013 passed by the learned appellate court in criminal appeal number 6/2013 stands set aside. Also, the petitioner is set at liberty. The bail bond executed by the petitioner stands discharged. Also, registry to send down the copy of the send down the records of this case to the disposal. You made me accuse you. I was against you, but thank you.
Item 4 was not done.
We will pass the orders next week.
Twenty-four, my lord. 2009.
Anything material in the conviction or that is proper?
Oh, I'm so, I mean, there is an allegation that a sharp cutting weapon was used. And all that medical report I'll come later, my lord. That weapon was not seized. No bloodstained clothes seized, nothing.
PW2 and PW3. PW2 is the victim.
Eyewitness happens to be a chance witness.
Maybe, but the learned trial court has also gone as to how he came there. He has also explained why he came there. So there is some material which shows. And subsequently, the people from the marriage party, they have also, although the injuries have been highlighted.
Simple, man. Medical report says it.
May 324, 2 years, the incident is of
The 9, my lord, fine provision for fine is also there. And he will be, my lord, about 40 years as of now.
Okay. Yes, Sir Kaushik. Conviction, we are not interfering.
Yes, madam, because there are
2 and 3, enough.
enough,
Hmm.
because in
In a higher position, and the
position, my lord.
3 is a chance witness, but he has explained why he is there.
Trans witness, but he is eyewitness.
He is eyewitness and he has explained why he came. He was a video parlor operator.
That, my lord,
That
when
evidence is direct.
direct evidence, non-recoverable. There are materials your lordship has.
So what we do is that we uphold his conviction under 324 after this incident is of 2009. 16 years have passed down. We will not send him to
2007, my lord. but,
7.
Conviction
Seven.
is of 2009.
7. Incident is of 13/5/2007.
Right.
We will not send him to imprisonment, but we will impose a fine which he will deposit within 2 months. How much? He is Mr. Goswami is appearing. The condition, economic condition is known. We need not have any doubt about the economic condition when Mr. Goswami is appearing. And if you say that after Mr. Goswami has appeared, something has happened, I have nothing to say.
Well, he has got no regular income, my lord. He does some petty business, this and that.
That we can understand, Mr. Goswami appearing, we can understand that.
50,000.
50,000.
My lord, that is on
Considering, my lord, because your lordship is
The
waiving that
incident,
conviction, my lord.
maybe the whole lifetime also, I don't know, my lord. Honestly speaking.
now maybe he is not in a position after pursuing this matter from 2014. We don't know.
After a very long time.
10,000. 10,000. But Mr. P.D. Goswami, learned counsel for the petitioner. Also heard Mr. R. Kaushik, learned additional public prosecutor appearing for the state respondents. The present, Mr. Goswami, please, Kaushik, Mr. Please, just have a seat. The present revision petition has been instituted, assailing the judgment dated 29/3/2014 passed by the learned additional session judge Dhubri in criminal appeal number 1/3 of 2009. As iman bhalmat loi ase ki hol kiba thik koilo ni. Dismissing the same and thereby upholding the judgment dated 4/9/2009 passed by the learned Chief Judicial Magistrate Kumar Dhubri in GR bracketed DBB bracket over case number 222/2007 convicting the petitioner herein under section 324 IPC and sentencing him to suffer SI for simple imprisonment for 2 years. So, the petitioner herein, being aggrieved by his conviction, had assailed the judgment dated 4/6/2009 before the court of the learned session judge at Dhubri by way of instituting an appeal being criminal appeal number 1 bracketed 3/2009. So the said appeal was taken up for consideration by the additional session judge Dhubri and wide judgment dated 29/3/2014, the appellate court, upon appreciating the evidences coming on record, was pleased to dismiss the said appeal, thereby upholding the conviction of the petitioner herein by the trial court. Being aggrieved, the petitioner has instituted the present proceedings. Also, ऊपर तो लिखा नहीं है prosecution case to लिखा नहीं है देखा the prosecution case okay shall we say you have consented to that fine?
My lord,
Without saying that we'll do it. Okay, done. Disposed of. What did it?
not so.
It's a complaint case actually. It's really- it was registered as a- There's a conviction under section 374-17, my lord. He was sentenced to undergo imprisonment for 6 months and a pay of fine rupees 500.
And also the compensation.
also compensation of rupees 20,000. The facts from the evidence, all evidence has not been correctly recorded by the trial court as well as by the. They were having an affair since 1994. There was an exchange of letters. And the refusal was come way back in 99. Then they entered into an agreement. And
That agreement is the basis of your conviction.
yes, but that agreement subsequently did not agree because she got pregnant. The pregnancy, she has admitted that not.
You have not asked for a DNA.
No, she has admitted not. I was not responsible.
Where?
In a cross examination.
Okay, just show me that.
That I'm coming to it.
But the learned trial court has not.
Dealt with me. That is the problem, man. Last part of the cross examination.
Record to court. Just read what is there. Examination of PW1.
My-
Is PW1 complainant. Cross examination. What is the evidence?
ইয়াৰ লাইন ইজ দ্যাট এইটো সত্য নহয় যে মোৰ গৰ্ভধাৰণ আসামী পঢ়া হয়।
And that is some writing error. Because the entire evidence is he is responsible.
Yeah, but
But নহয়, read it once more.
সত্য নহয় যে মোৰ গৰ্ভধাৰণ আসামী পঢ়া হয়। Assam is not responsible for my pregnancy. Last one. 6 নম্বৰ পেজত প্ৰচত because that was the bone of contention because there's another person who was staying with her there. Result, the defense came up because it was a love affair from since 1994. There were exchange of letters also there. That has been exhibited.
The last.
1-9.
That one line he says that.
That you forget for final clarification. That some question you put that came out like that. You were there during the cross, no?
No, it wasn't true. That matter.
So that is there.
And therefore, she got aborted also.
Well, fine, whatever it is. But
is also.
the agreement that was there, that led to the belief that she is literally a married girl, your wife.
Now, question of 417, my lord, there is
There is a misconception of fact here.
yeah, no, there is a no.
Because
Because first of all, I have to induce her. That inducement is not there.
that inducement is the agreement.
Because prior to agreement, I had an affair with him.
Be that as it may,
Because she has admitted since 1994. And
Mr. Kakoti, if I'm wrong, just tell me. You had an affair, then you solidified that with that agreement.
No,
That agreement is correct, wrong, that the legal people knows. But a common lady was under the benefit. It's an agreement for marriage.
we stayed together.
I know there is evidence to that.
I stayed in her residence also.
The mother-in-law treated you like son-in-law.
So the relationship is there. We are not admitting it. But that I not induce her belief. That inducement is not there. Because it's a case of 1994.
20,000 of 2003 is not 20,000 today. So we'll excuse you from the jail term, but how much are you willing to give? No, no. Consent, fine. That is why 376 is not there.
Not a case of 376.
No, no. If there was no consent, it would have been 376.
Consent mean regarding the amount, my lord, I think.
What is he doing?
He was a petty businessman, man.
What happened to the girl thereafter?
We don't know, my lord. I have to try. This about my client, my lord.
The way lordship induced receptions is
Because
no,
470,
agreement till not.
their decision so means that right from the inception, my lord. If the inception started, is
The inception was love affair. So love affair is,
from 94, my lord.
the agreement is of no use, but in a criminal case, that might have given her the belief that yes, I'm now his wife.
That
Lordship consent is obtained from the
And see the conclusion at page 34, last line.
whole person is another thing, my lord. Right from the inception, he was having. He has got the intention to cheat, my lord. That part is
See, the intention can be drawn in execution of that agreement.
understand.
Because that situation got bad between you both, and it was at that point of time that the agreement was executed. That shows that you did not have a bona fide thing in here.
I understand, but I given the reasons because she became pregnant, my lord. Due to the pregnancy, but
And the pregnancy, she has said that it is you.
that one part is denied, another part,
That we'll take it as a whole.
yeah, whatever it is, by the but there were issues some regarding that part, my lord. The result, relationship broke down.
So
not brought on record.
For cases that when the relationship started way back in 1994, there were exchange of letters. The letters were also exhibited. So she has the letters. It appears that she has also remorse and she wants herself, my lord.
Oh, okay.
So from there,
Just see the agreement. No, just see the agreement. It is an exhibit.
the agreement, your lordship.
Just see the, I think yesterday I went through the top portion. It's not a agreement for, no, it's not an agreement that the marriage would, it's a marriage agreement.
Where is it?
It may be a void thing. It would have no, but as far as the girl is concerned, this is what induced her. This is what solidified her belief.
So before the agreement,
What is the
also,
language used? Huh?
In English.
What is the language
I have
used?
enclosed, my lord.
May I read?
You have enclosed, yeah,
Yes,
somewhere I found.
page 22, my lord.
May I read?
Just a minute, it's here, it's here, it's here. No, no, just okay, it's okay. This agreement is dated 20th January 2000.
Prior to that, my lord, they were having a relationship.
And the medical evidence checkup, the pregnancy is,
So has been examined, my lord.
Doctor said-
PW 5.
PW5. 10 weeks. So this pregnancy is after the execution of this agreement.
Till 22/1/2001, madam. Expected delivery. Months, madam, that will be.
It was 22.
After the agreement.
But
So, and you come to the agreement. Affection, the parties. Society of each other and intend to live so far which purpose they have agreed to enter into such agreement as on here. So after this, within 30 days, you were supposed to have the marriage.
married.
We have not done it.
There was a violation of the agreement.
So how much?
Now
How
the
much?
question is that
How much?
now the physical relation, whether there was any physical relation prior to the agreement.
There can be. We are not concerned with that. We are concerned with the pregnancy, that occasion admittedly after the agreement.
Understand, Malik? If they had a physical relation prior to the agreement, if it is so, then because what is from the since it appears in 1994, they were exchange of letters. She also wrote letter to him. And also they had a relationship, physical relationship, but he refused to marry. He lost an FIR also. For that. It's me, my lord. Assaulted him. And openly, my lord, there was a village also was there.
How much?
That I have to take consent. That's why I'm like this.
Evidences are very sufficient,
But
conclusions drawn does not suffer from any infirmity.
no, if your lordship take is the earlier relationship, so having a physical relationship earlier in the point of time. So then 470.
Then if it was just a physical
was-
relation,
yes, it was
then what
complete.
was the need of this execution of this agreement?
Agreement because but they want the conformity that the
That
violation of agreement doesn't amount.
no, I'm not on the violation. By agreement is void. But
Yes,
I'm only construing your mind,
And
your intention.
70 says, my lord, right from the inception. Inception will come in the way back in 94. They will later.
That can be construed. Yeah. Otherwise, if that was not there, you would not have executed this agreement.
Because our relationship.
You wanted, maybe you were in a tight situation. You wanted to move out, wriggle out of that. You executed this.
FIR was filed against me. They have yesterday.
The affair is thereafter.
No, prior to this.
No,
That in evidence it has come. It has.
FIR is
The complaint is not FIR. That earlier in point of time, they filed an FIR.
where do
Where
I
in
get it?
you can see, my lord, he has said whether, let me see the complaint, my lord, whether he is stated or not. But in the examination sheet, she has stated, just he lost an FIR.
The complaint is of July.
July. The FIR was long back, my lord. And there was an office bell. Can don't, if your lordship gives me time, I can translate the copy of it.
No need to translate.
Because all portions are not readable, my lord. Where in the complaint because she talks about only the agreement part. That part she has not narrated anything about that.
And paragraph 11, cohabitation, 3 months pregnancy. Even if we hold that the inducement is from the date of the agreement, that is enough. Earlier, there might be love. There was no physical relationship.
That I'm coming to it because
There is nothing here. The complaint also starts from the execution of the agreement.
of the earlier part.
No, no, no. Earlier, if it was there also, that was just a precursor, but the inducement occasioned after this agreement.
আখিত কৈছিল মই 1000
If you come to page 30, the extraction of the PW1's thing. I think, Mr. Enough.
if I get a Tesla copy, Lordship, for your satisfaction,
I don't want to translate it. You read that if you have any doubt. You want to read it, just read it.
that's
PW1.
বিয়া কৰাম বুলি জনাওটো স্যাৰ 94 পৰা আৰম্ভ হৈছে স্যাৰ একচুয়ালি
Read further.
তাই বিয়া কৰাম বুলি সম্বন্ধ সম্বন্ধ হ'ব পাৰে হ'ব বিচাৰে আৰু আৰু সম্পৰ্ক কৰে আৰু আসামী মূল আৰু চিঠিবোৰ আমি লৈ যায় এই বস্তুবোৰ মোৰ আসামীয়ে মোক বলপূৰ্বক ভাৱে লৈ যায় তেতিয়া মই উগদৈ থানাত এজাহাৰ দিওঁ so that is prior to the agreement
Read further.
আসামীয়ে মোক বিয়া কৰাম বুলি কোৱাৰ পাছত আসামীয়ে সময়
Mahila committee will come in somewhere.
নকৰা কাৰণে মই কাইলি মহিলা সমিতি মই থানাত সমিতি আৰু ভোগদৈ থানাত জনাও তেতিয়া মহিলা সমিতিয়ে এখন মোৰ মেল পাতে কিন্তু আসামী উক্ত মেলত লগত কোনো সম্পৰ্ক নাই সম্পৰ্ক নাই বুলি জনায় তিনিটা মেল তাৰপিছত মোৰ পাছত মহিলা সমিতিয়ে থানাত জনোৱাত আসামী ভাৱে মোক লিখিত জানুৱাৰীৰ ভিতৰত কোৰ্ট মেৰিজ কৰি লিখিত প্ৰস্তুতি দি দিয়ে মই
That is that agreement.
so prior to the agreement
Read further. Read further.
আৰু গোচৰত দিছিলো যোৱা 20/1/2000 আসামীয়ে মোৰ আদালতৰ আহি এখন বিয়াৰ চুক্তি কৰি উক্ত চুক্তিখন ৰেজিষ্টাৰ্ড কৰা হয় পদক 1 উক্ত চুক্তি
And now read further.
মই আসামীক কি ক'লে
Where Assam?
পতি পত্নী হিচাপে
Ah.
চুক্তি কৰি আৰু কোৰ্ট মেৰিজ কৰিম বুলি চুক্তি কৰো উক্ত চুক্তিখন মই আসামী পত্নী হিচাপে সেইদিনাৰ পৰা থাকিব লওঁ কিন্তু মোৰ ঘৰৰ ওচৰত থকা
Next line, Lord.
আগে ঠিকে আছে
She did all her.
আগৰ কিন্তু ঘৰত থকা পইচা আসামী ঘৰৰ
Two, 3 lines more below.
তেওঁৰ পত্নী হিচাপে থাকো মোৰ লগত স্থাপন কৰিব
Correct. So that inducement is there, at least after that. thing.
from the area said Ali also
You only executed that agreement to fool her, to get wriggle out of that situation wherein she approached the Mahila committee, police. To get out of that, you did it, but still you maintained a relationship.
the relationship earlier in point of time
Earlier in point of time is nothing. This is the one.
because I had a physical relationship
That is enough.
right
How much? 50.
let me take
Let me know by 2. Why carry this matter for another day? Finish it off today only.
After half an hour like this.
Oh. None appears for the petitioner. Parties on call. Registry to list this matter again on 10. The 10 G date, right? Could be that date already. Yes. 13.
Just come for order, my lord.
Service upon respond number 2 is not complete.
My lord,
Notices were-
For 2016, my lord, we have taken steps, only AD card has not come. Probably it is not required also. When the party, though I have made party to the informant, but it is not required. It is case of suicidal.
Decide.
Yes. Case committed 306 has been implemented. There is absolutely
306, your Janmuni.
yes, no evidence at all. Our high court,
But the FIR that this is pursuant to the demand for dowry.
there is in the evidence nothing. My lord, she
You are enjoying you have been bailed out by this court, enlarged on bail by this court.
Honorable court has, at the time of admission,
The inconsistencies were noticed. We'll appoint a amicus. What's up? Heard Mr. S.C. Biswas, learned counsel appearing for the petitioner. Also heard Ms. S. Bora, learned additional public prosecutor appearing for the state. What's up? None has appeared for the respond number 2. What's up? The office note reveals that the steps were taken. However, the AD card nor the unserved notice has been received back by the registry. Full stop. According full stop, the trial court records have also been received. Full stop. In view of the above, a registry to appoint an amicus curiae from the list of amicus curiae already available in the matter for the to represent the respondent number 2. Full stop. Registry to list this matter again on 18/11/2025 for admission for reflecting the name of the amicus curiae appointed for the respondent number 2 in the cause list.
Respect to item number 12. I'm for the petitioner also.
Oh, Mr. You were
For the petitioner, I'm here on behalf.
you're not there. Your name was
R. Kumar, Your Lordship.
R. Kumar. Mr. R. Kumar, on behalf of Mr. U.K. Burman, learned counsel for the petitioner is present. None has entered appearance for the petition for the respondent. Accordingly, for the ends of justice, registry to list this matter again on 18/11/2025. So an endeavor would be made to dispose of the matter on the next date of listing.
On not on 18th or
20. 20.
Number 11, make it 40,000, my lord.
40,000. Disposed of. Shall we record your consent for that?
Yes.
I'll pass the order. This you're for item number 14. 14. Trial court record, I say 14. No? Also, heard Miss
Yes.
P. Das, learned counsel for the
A, B, B.
B. Das, learned counsel for the petitioner. Also heard Miss Bora, learned additional public prosecutor appearing for the state respondents. Also, office note dated 10/9/2025 reflects that the service of notice upon the respondent number 2 has been completed. Also, accordingly, Also, the trial court records have also been received. Accordingly, registry to list this matter for admissions. After other admissions on 18/11/2025.
Yes.
Yeah, 11 today.
Item number 12, Your Lordship. Can it be fixed on 19, Your Lordship, 20 or 19?
19. But Mr. Kotogi has said I can record his submission for that. But Mr. B.P. Kotogi, Learned Counsel for the petitioner. See, Mr. Kotogi is somewhere here round about. Also heard Miss. Huh? Nobody for respond number 2, na? S.S. Bora, Learned Additional Public Prosecutor appearing for the state. Also, Madam, so we accept your concurrence for that. Mr. Kotogi will not go into the merits. We say it is done. However, fairly submits that the penalty be
For age of justice?
the imprisonment be done away with and the compensation be
And has to forward it.
So the present revision petition has been instituted, assailing the judgment dated 29/3/2014 passed by the Learned Session Judge, Jorhat in Criminal Appeal number 5/2004, dismissing the same and thereby upholding the judgment dated 16/12/2003 passed by the Learned Judicial Magistrate First Class Jorhat in CR case number 162/2000, convicting the petitioner herein under section 417 IPC and sentencing him to simple imprisonment for 6 months along with payment of fine of rupees 500 in default to undergo simple imprisonment for 1 month. For the Learned Trial Court also directed for payment of a compensation of rupees 20,000 by the petitioner herein to the respondent number 2. Also, after Mr. P. Kotogi, after attempting to argue the matter at some length, has submitted that the Learned Court below having returned concurrent findings, this court may not be called upon to reappreciate the evidences coming on record. He submits that the incident occasioning in the matter, the offense committed by the petitioner in the matter was so committed in the year 2000. 25 years have passed on since the date of commission of the offense by the petitioner herein. Accordingly, he prays that this court would be pleased to exempt the petitioner from the punishment of imprisonment as awarded by the Learned Trial Court and limit the punishment to that of fine, which is permissible under the provisions of section 417 IPC. Mr. Kotogi further submits that the compensation as directed to be paid by the Learned Trial Court would be also paid by the petitioner. Also, this court accepts the contention of the Learned Counsel for the Miss So-and-so additional public prosecutor submits that the compensation awarded was so awarded in the year 2003 and around 22 years have lapsed. Accordingly, this court would be called upon to enhance the compensation, which she says should be commensurating to the value of money as on date. First, I've heard the Learned Counsel for the parties and also perused the materials available on record. In view of the submissions made by the Learned Counsel for the parties, this court is of the considered view that the long lapse of time occasioning from the date of commission of the offense by the petitioner herein, he be not directed to undergo the sentence of imprisonment for 6 months and the sentencing of the petitioner be modified to that of imposition of fine of rupees 500 in default to undergo simple imprisonment for 1 month under section 417. Also, the penalty of rupees 20,000 as imposed by the compensation of rupees 20,000 as imposed by the Learned Trial Court be enhanced to that to rupees 40,000, and the petitioner herein shall pay the amount of rupees 40,000 within a period of 2 months. 2 months from today, before the shall deposit the amount of rupees 40,000 within 2 months from today before the Learned Trial Court. The trial court, on realization of the said amount, shall release the same to the respondent. Number 2 herein. I'll do that. This is exactly this book. No, my again.
Some line.
Huh?
The merits part.
And we will do. I'll do that. I'll not put it directly in your mouth. Just took a undertaking from
Yes.
you. Not that surely. We'll only go by that agreement. Why that agreement was. This is for my guidance. Yes, Yamata 8. Now we can concentrate on Mr. Kamal. Kamal's matter. Yes. Yes. Madam, if I just to recapitulate what had happened, he had taken a preliminary objection. You have placed that documents. We'll take a call upon that, whether it is maintainable or not under Section 6 of the DSP Act. The documents that notifications that you have produced forms part of the FIR filed by the CBI, and these 2 documents are there. It was exhibited. So ordinarily, it was also, this document also gets exhibited. It's available in record also. So the preliminary objection may not stand. Now the plea of argument of Mr. Kamar is that this was a case which began with the conspiracy 120p leading to 420. So he has tried to project that 120b being not in a position to be applied because one of the accused, there were only 2 accused, one of the accused being acquitted. So 120b goes. So it's only 420. Now on that day, we found that while we were going through that the amount of rupees 10 lakh something, 73,000 was in terms of a letter written by the petition appellant herein to ASCAD, praying for investment as an equity. Right? Now, that letter is dated. That letter is dated. Oh, Exhibit 5 to some. And when was the Poltam Bazaar? 98. Yes, is 98. Now, madam, from 96, when this letter was given, the money was released, withdrawn on. When was the money withdrawn?
Is withdrawn on.
That is 16 to 96. And when was the payment actually released? PW? No, it ends of 5,000.
Exhibit 27, 28.
No, no, I wanted 10,73,000. So 17 to 16, he gave the letter on the same day the money was released.
Involvement of the
But with regard to this allegation, this is the only charge sheet. This is the only. Okay. What material is there, madam? If it is that I told you that this is equity,
yes. So
fine.
there is two things. Society is not pro.
Just what is the evidence to that effect? No, madam. That the mere that it was an equity investment, that will not do. You will have to take it further. That after you said this, you closed down, you did not.
Card Bank.
And what prevented CBI from bringing 319, bringing in the other persons in this case? Because the evidence is very clear. Once you have adduced 5,
Another accused.
okay, fine. That we understand. Madam, if you can come to page 52. Judgment, madam. There was no board approval also. Cahots. So admittedly, he had taken this money. Immediately thereafter, he shifted out from that building and the whole thing is closed now. After that, Assam Food Products is not an existing company. What is that? What is that evidence? PW?
Also said it is not functioning and PW 14 register. And got paid either. But is that or is memorandum of association is there? Bank is also. No balance sheet. Had there been no memo
has been adduced against me, then if need be, I'll have to rebut. But there is no rebuttal provision, legal fiction is there. Like a person taking a bribe, my lord, section 19 is there. Since your hand has turned pink, money was found in your possession, so you have accepted the bribe. That legal presumption operates. Like issuing a check, the basic principle is that you have issued against your liability. But these are all rebuttal. But here on this type of criminal misconduct cases, 420, there is no question of rebuttal, my lord. It is the prosecution who will have to establish
Okay.
the case.
Okay.
So now let us come to what is the evidence on record. PW1. The list.
So the evidence that we have to now
Yes,
search for
Marshal, now we have to.
is only with regard to 10,73,000.
Yes, my lord. Now, the court, while convicting me, was not sure what was the amount cheated. One, because the big in between there were two figures, 18, 17, and 10. So there was an or. I might have cheated 17 also. I might have cheated 10 also. Why it was given now? The question will, if it's passing in your lordship mind, I'll try to respond it, my lord. Why that two figure has been to be written in the
So
judgment?
we'll come to that. Let us go through the evidence.
See, no, I'm just giving first, these are the infirmities in the judgment, basic infirmity. While Binu Talukdar is the person who was the account officer at Ascot, who has categorized the checks issued. That is 1, 2, 3, 4, 4, my lord. Now the check has been given to me on 4 checks as I have received, my lord. Your lordship will see. The first is that 10,73,900. Then if we total it, it comes to 17,33,900. The lordship will kindly total it. We'll see that it is 17,33,900. So 17 lakhs is the amount as per evidence it has been given. Charge is of 18 lakhs and finding is on both. Now, which three figures are emerging?
We'll come to that.
Then
That
what-
by itself cannot be a
That
thing
itself
that
is
has to
down
be
because
taken,
what
that it
amount
is
I
not
have
supported.
actually cheated.
No, that
Ah.
amount that has to be supported by the evidences. Let us see the relevant evidences.
I'll come one by one. Then first I'll give the list, my lord, who is what. He is the person, accounts officer of Ascot Bank, who has
PW1.
stated all these things, my lord.
Vinod Talukdar.
Yes. Then we come to the Aswini Bajpayee. He is the bank manager of Indian Bank, wherein it's my bank account, the food product. Then Deepak Deka is a typist, my lord. Yeah, bro. Deepak Deka is a typist wherein the Imran Shah ordered 6% to be support person of the that product limited.
The cloud created is there were two companies. One is the cooperative society, one is the,
Product limited.
to me. The checks have been exhibited.
My lord.
Checks have been exhibited.
Yes, my lord. Exhibit 1, 2, 3, 4. And these 4 checks, when we total it,
What is the name of the drawer there, drawee there?
that is the Assam Food Product Private Limited, my lord. First page, if your lordship will see the evidence.
Tell me how this was issued to, what is the evidence with regard to issuance of check to Bhaskar this? Because the equity was, infusion was sought for in the cooperative society,
Hmm.
not in
Food products.
Food Product Limited, but society. Both, the account shows that the equity infusion which was done in cooperative society, check was issued in the name of the limited and it was drawn by the petitioner himself from his own account in the bank.
No, that's a bank account of
Bank,
the company.
that is, he is the signatory.
Signature, of course. He being the MD and he is the signatory, my lord.
Okay, we got it.
Now, my lord, that is what, there are lots of latches on the part of the prosecution to prove the case. Now come, my lord, to the other, your lordship is taking the evidence, my lord?
Yes, you can.
Yes. No, if your lordship is looking, then I'll read it together.
No, please, you tell me where I have to read,
Yes,
I'll
my
go
lord.
there.
I am on PW1 accounts officer who has stated about the check. Now let us come to page 2, my lord. In the middle, my lord.
Mr. Kamar, you also agree that you are a part of this Assam Food Products Limited.
My lord, they have not produced any such evidence. How am I? But I'm only soon, that's what I'm reading, my lord. For fairness, I'm pointing it out.
You can come to PW2.
Yes,
straight.
He is Oswini Kumar Bajpayee. He was the Assistant General Manager,
Hmm.
Indian Bank.
Second paragraph.
Yes.
On Exhibit 20, both sides, is
Both
the
sides in
opening
the account
form.
opening form of the Indian Bank Beltala Bread in the name of Assam Food Product Limited Cooperative Society, and this account opening form was filled up by me. This is an ad hoc opening form. In my initial with instruction to open the account is the signature of Ashok Soikia, being the Managing Director MD of Assam Food Product Limited. Exhibit 22, both sides is the specimen signature from which is the part of the account opening form, which also bears the signature of the introducer Osman Jalam. This is PW5. The person who accompanied me to a French. Showing his address as 61 Hotel Empire Complex, HB Road. The address of the Sheikh Ashok Kumar Jalan is the signature. The account which was opened in the name of APL can be operated by Ashok Soikia himself as well as by Hemaprabha Soikia being the chairperson of APL. Exhibit 22/3 is my signature.
Why did you accept the check in the name of Assam Food Products Limited?
That is what I am today pointing it out. Now that question has to be put to me under 313.
It was put to you under 313.
Yes,
You come to 313.
ma'am.
That circumstance was put
Yes.
to you. When the circumstance of TW2 was put to you,
Now, he said that he is not the account holder. The whole question, one jumbo question has been put.
neither does, but the circumstances are there.
The circumstance not. It is only the narrative, not the circumstance, my lord, with all respect.
You come to the your examination under 313.
My lord. My lord, 313 has got its own way. to ask.
Come to PW1.
Yes, my lord. One jumbo, whether that is permissible under the law, I'll show that.
Yeah, see, the check was issued. Another check, so and so. 10,73,000 I found somewhere.
These are the checks, my lord.
Checks have been issued.
Whatever it was used.
For rupees 10 lakh, so and so. For by Kiresho Soikia, did and so. Now you see your reply.
As per decision of the board.
So and so adoption. I am connected with Assam Food Products. Even before my joining, Limited had initiated business activity of so and so.
Which question, my lord?
Question number 1,
Oh, yes.
answer.
His reply was as per decision of the board of Ascot Bank.
No, no, no. Question number 1, Ashok Soikia.
Also,
We note that you are reading,
both together. Correct.
please see the reply. Yes, ma'am. Assam Food Product Cooperative Society was registered by the Register of Cooperative Society, Government of Assam on 20 with adoption of bylaws wherein the I'm connected with Assam Food. Read your answer with regard to question number 2 also.
I'm connected and related to a same answer, madam.
No, no, same thing, but read it. There is a difference here.
Yes, sir. Cooperative Society form under the Cooperative Society and register society to the in the file marked. The bank account CA belongs to Assam Food Product Limited and not to Assam Food Product Cooperative Society. They are paid to Assam Food Product by the Ascot Bank as its share money contribution toward Assam product. Similarly, the amount of 10,000 1.50 1073 were paid by Ascot Bank Limited to Assam Food Product Limited share money. The check issued by Assam Food Product Limited were of conducting preliminary business activities of the soil industry and were normal business transaction only. The statement account of CA of Assam Private Limited and pertains to normal business transaction with various parties. So it was a purely a business. Thank you.
Mr. That unfortunately is not sustainable because the very application basis was for food products cooperative society.
Yeah, then it is the prosecution to say this segregation. They have made it in a one manner that we have given you
Okay.
total this.
Anything more?
Yes, my lord. Now, on what basis the case is progressing? Because the case is progressing on the basis of the cooperative society, my lord. If we come to the evidence of PW1, my lord, that share money part. What is the evidence on record? Exhibit 5/8, my lord, last slide. Para. That is the note sheet 5N. A total amount of 17,33,900 was reimbursed against the share in Assam Food Products Private Limited. So share of Assam Food Product Private Limited is given for that 17 lakhs.
Note number 5, exhibit 5A.
This is a prosecution story, my lord, coming out in chief, not in cross. That we have managed or got written. It's not that way. Prosecution has asked, he has replied.
The extent of manipulation.
I don't have a privy to see the record by the right.
See the records. Just go through this 5. This was permitted to be adduced without any objection, exhibited without any objection. Just go through that. Open the file. Just close the file once, Mr. Just close the file once. Then go to the first note sheet. Or before that letter. Just have a look at the letter. There is a letter there. That letter starts it off. Letter from equity, that equity letter. That one. That one. Just see the headline, the banner of that letter.
Assam Food Products Cooperative
Limited. Equity. Now come back to the note sheets.
Yes.
That is the first thing which says that this is the letter we have received.
I'll read for you, Lordship.
No, you read it for yourself.
For Managing Director, Assam Food Product Limited, of their office in this country. Here it is 17 lakhs 33 given to Assam Food Product. as
That is
their money.
total. Assam Cooperative Society.
No, no, here it is Assam.
See
Food
the note
Product.
of Imran Shah.
Everything is writing.
Imran Shah.
Office note at 5 May. Present, the CEO has passed the order. For this, we may.
Madam, you have nothing more to add, I suppose.
Mm.
That will also not. That because the letter was for the society, money was released to the company. Yes.
Companies that
And that was approved by the chairperson of products. Okay. Got it. Mr.
To that, I'll kindly respond, my lord,
Hmm.
that this is a criminal trial.
We
The
got it.
proof- The proof is beyond reasonable doubt, and the charge is of regarding 1733, my lord.
Or 1833, what it is.
1833.
That this court has
Yes,
to
that is what
examine.
I'm saying. In charge it is-
1877
yeah,
or 1733.
Is 1877, 900 in the charge, and in evidence, if we calculate it, it comes to 1733.
And there
judge-
is no explanation for that.
And the judges has written it as 1073.
Mr. Kamar, would you like to file a amended written argument bringing in these aspects of the matter also
I can.
with regard to that cooperative society submitting an application and you being both in both the thing,
both.
you wedding person. 313 questions are there, your clarifications are there. We can take note of that in an appeal. So how do we proceed in that? How do you want to project it? Madam, you also give me a small note. Only on these points. How long will it take for you? 1 week. Okay.
Only one.
You, madam, you just give it to me in your.
My lord, this is not economic only 420 IPC. Everybody cheating is going on, my lord. This is not I am not facing the PCA case. Madam, I'm. not
Madam,
facing
420 is
PCA
enough.
Out.
At least till
The
now,
man who gave.
tentatively, 420 is enough. Let us see what Mr. Kamar comes up.
My lord,
And
only-
after that, if there is something required clarification, I'll
Yes,
take it. We'll not carry this forward anymore.
Yes.
When can
one
we
day
fix
will
it?
be Good enough.
Let us fix it on 6th,
My lord, 6th, I will be probably out.
7th, 8th.
My lord, I'm giving, my lord. But বাইরে যাওয়ার কথা আছে না? Any date, my lord.
10th.
7.
7. Okay, 7.
8.
8 is holiday, 7th. Madam, 7th is not.
Or can
Heard
it
the
be
Lana
11th,
Council for
my
the
lord?
parties at length. However, hearing remains inconclusive. Also, Lana Council for the parties are at liberty to bring on record their written submissions by way of an affidavit incorporating their stand in the matter. Oh, by way of by incorporating
Agency
their
also-
stand in the matter. Full stop. Registry to list this matter again on 7/11/2025 for further hearing.
My lord, can I take one favor from your lordship? My lord, 13 it's missing from my file. Of Ashok Shekhia only. Imran Shah, I have it.
You have that free, take it from.
Then I'll give it back.
Madam will provide you with that. Xerox copy. Get it Xerox, Mr. Chaudhary. Everybody.
It's fine.
Records so asena. So 11th, we'll close it on 11th. We'll close it. I'll go through. If something is there, clarification,
Yes,
I'll
sure.
close it and then we'll take your notes and close it.
Oh,
And your decisions, madam, you give me on that day. Thank you.
much of it. এইখিনি কৰি আনা মেডামৰ ফোন নম্বৰ এইখিনি সামৰি লব নালাগে